Oh, I can't go.
When I went to Northeastern.
Okay, today we actually start what I call the fun stuff, care and protection. And this is what I want you to do. If you don't have this, the statute or anything printed with you, I'm gonna be referring to specific sections of the statute and at the same time referring to some of the cases. So take notes. Today I'll be doing most of the talking, although I'll ask you questions as well. So let's begin. Let's begin with, how about just a little hypothetical? So suppose that, I'll pick on you, Danielle, since you were just talking about your family.
Sure. I'm an open book.
All right, so suppose you sent your daughter to school and she's 10 years old. And when you sent her to school, Kelly's her teacher. And a few times, Kelly had observed her looking a little disheveled sometimes. Sometimes she hadn't been sleeping. And a couple of times you observed actually bruises on little
Nicole.
What?
Nicole.
Nicole, all right, we'll call her Nicole, all right? So, let's talk about your responsibilities under the statute, right? So that's 119, what section?
Would that be a mandated reporter?
Yeah, what section of the statute? And if you don't have it, note it down. It's 119.
51A.
51A,
Oh, I
correct?
did it.
Actually, you know what, could you first look at section 21, which is the, Norman just said, who said mandated reporter? Norman? You did, didn't you? Okay. First look at 119, section 21 contains some definitions. And there is a definition of mandated reporter. And I just want you to notice that there's like 4 categories of mandated reporters. The first category is like the medical, right? Physician, medical interns, hospital personnel, etc. And there's a whole list of them. Second category is where Kelly would fall, public, private school, and so forth. Child care, residential services, there's a whole list. So let's call that the school category.
Like a daycare?
Yeah, that's all in there. That's all in the very long list of mandated reporters. The third category is your probation officers, your police officers, other people in the court system, clerk, magistrate, parole officer, social worker, foster parent. That's the third category. The last is actually the newest category, and it's the clergy. Priest, rabbi, ordained licensed minister, leader of church, Christian Science practitioner, etc. Okay? So those are the 4 different categories of mandated reporter, and it's 119, section 21 in the definitional section. There are other definitions in 21, and I'll come back to it. But I just want to go through the reporting process first with this little hypothetical. So, now turn to 51A. We've established Kelly's a mandated reporter. She falls within the classification, for classification purposes, falls within the definition of mandated reporter. So, we go to 51A. And let me just say that all 51A is a reporting statute. That's what it is. It has nothing to do with the courts. I mean, it may ultimately result in court action, but all it is a reporting statute. So 51A, section A, 51A, section A gives Kelly sort of the parameters for what the standard, by which she's required to report instances of abuse. And the standard is, can anybody just give me the standard? What would cause her to have to report to the Department of Children and Families this family? Yeah, reasonable cause. And it's right, the standard is in the statute, clear. A mandated reporter who, and notice it says in his or her professional capacity, has reasonable cause to believe. I'm reading right from the statute. Mandated reporter, who in the, you don't have to write this down, just write the section down so you can look at it later. Who has reasonable cause to believe that a child is suffering physical or emotional injury resulting from A, abuse, B, neglect, or C, physical dependence on addictive drug at birth. But notice it's reasonable cause to believe that a child is suffering from abuse or neglect. The statute does not define abuse or neglect. I've put on the board, DCF is the agency, Department of Children and Families. By the way, some of the old cases that you're reading say DSS, Department of Social Services. It was renamed a couple of years ago.
And there was even one that was DPW.
Yeah, Department of Public Welfare. Yeah.
And that was, must
The
have been.
department
Is that
came
the
about in
predecessor?
about the early 80s, so anything around before that would be Department of Public Welfare. Yeah, so that predated DSS, and now DCF is the agency formerly known as DSS.
Why change it
As
though?
Judge Blissman calls it. They changed the department at the same time that there was a sort of reorganization of agencies in the Commonwealth. The Department of Education became the Department of Elementary and Secondary Ed. Am I saying that right? DESE. And the creation of the Judge Garinger, who used to head up the Middlesex court system, then became the Office of the Child Advocate. So they created all kinds of new stuff in the last couple of years. Anyway, it's DCF. If you see DSS, it's the same thing
What is
in
it,
your
Department of
cases.
Child?
Department of Children and Families. So this is an agency, very important for our purposes as you're studying juvenile law. Because what does an agency do, right? Or what is an agency?
Well, it would be acting on behalf of the Commonwealth.
Yes, and it promulgates its own rules and regulations. And the rules and regulations pertaining to children is contained at 110 CMR, the Code of Mass Regulations. 110 CMR. And it's in 110 CMR that you'll see things more specifically, like the definition of abuse, the definition of neglect. I gave you an old article written by Nan Elder, and even though it's old, some of the definitions remain the same. I just want to briefly read you the definitions of abuse and neglect. Just listen, you don't have, so just note down that they're contained at 110 CMR 2.0. That's where all the definitions of the items pertaining to Department of Children and Families is. So abuse is the non-accidental, just listen to it, non-accidental commission of an act by a caretaker on a child under 18, which causes or creates a substantial risk of physical or emotional injury. And those are defined too, a substantial risk of physical or emotional injury. Or, and we'll read about this next week, or constitutes a sexual offense under the laws of the Commonwealth, or any sexual contact between a caretaker and a child under the care of that individual. That's abuse. This is neglect. So notice, abuse is the commission of an act. Now neglect is the failure by a caretaker. So it's not acting, the failure by a caretaker, either deliberately or through negligence or inability to take those actions necessary to provide a child with minimally adequate food, clothing, shelter, medical care, emotional stability and growth, other essential care. Provided, however, and this is important, such inability is not due solely to economic reasons. Okay, so abuse is the act, neglect is failure to act. Now here's emotional injury, an impairment to or disorder of the intellectual or psychological capacity of a child as evidenced by observable and substantial reduction in a child's ability to function within a normal range of performance and behavior. We'll talk about this next week. On Tuesday, we're going to do domestic violence and its effect on children. It falls into this area of emotional injury. Physical injury, something you can see. Death, fracture, subdural hematoma. So the example that I gave you might have been neglect at first, but then also abuse, physical injury. The CMR also mentions any non-trivial injury. It also mentions soft tissue swelling, skin bruising. The skin bruising is dependent on the child's age, circumstances, and so forth, and location of bruises. It also includes the addiction to drugs at birth. It also includes things like failure to thrive and so forth. So again, most of these things are defined in the regulations. The statute is much more general. So getting back to Kelly as the mandated reporter, she's got reasonable cause to believe that Nicole may have been maybe neglected or abused. She's coming in various states that, maybe she's not eating, maybe she's not clothed correctly. And then you also see bruises as well. So under 51A, you're going to report. Okay, so 51A, actually subsection A, is where we are at right now. The other important part of 51A that I want you to take a look at is 51A subsection A, I just summarized. 51A subsection D tells you what this report should contain. So Kelly is probably going to go to her supervisor too. She's a teacher, she'll probably go to principal, vice principal, etc. And then an actual written report at some point. I mean, you're going to call it in maybe right away, but the written report is going to contain specific information. Names and addresses, the child's age, the nature and extent of the injuries, the circumstances, the name of the person making the report, and so forth. So everything that needs to be in that report is summarized in the statute. Subsection F is anybody else. So suppose Danielle, that a neighbor overheard you beating Nicole daily, and the neighbor said, you know what, I've had enough of this. The neighbor, on his or her own, not mandated, might also report under 51A to the department. So that's contained in that particular part of the statute.
And that was under 51AF or no?
51A section F is any person.
I don't have a section. I'll have to.
No. That's from my CD?
I don't have your packet. There was no statutes in the packet.
Yeah, the statutes are at the end.
Oh, smart.
Yeah, there's like an addendum at the end, and the statute is at the end.
I took this off the general laws.
That's fine, you could do that too, but it is in the packet, it's at the very end.
That's 51BF.
Oh.
I don't think they have it on the mass laws. It's under.
Yeah, it's at the end, but it's at the end of your packet.
Okay.
Okay. There's other sections of 51A. That's the important stuff. I don't expect you to become, expert practitioners in this area. I just want you to know the general stuff. And that's the general information that I would expect you to know. That's the category of mandated reporters, what their standard is, other people that can report, and again, this is a reporting statute of 51A. I want to move to 51B, but I saw Elizabeth's hand up.
So a question would be, teachers are obviously mandated reporters.
Yes,
but
yes.
Can they report it to a social worker at the school rather than the department?
No, the report is to the department.
To the department?
Yes,
Directly.
yeah.
Okay.
I mean, they may, she being a teacher would probably go to whoever her superior is.
Right.
She might talk it over with the guidance council. There might be other people involved in knowing sort of Nicole's status.
Yes.
So that maybe the school nurse, so there might be others. That's the thing too. If the department gets a call and then another call, so that they're just sort of multiple reporting, they might screen out some of them because it's all sort of the same report, on the same incident, the same child and so forth. But more than likely from the school, the actual report to DCF won't come directly from her. It would come from, one of her superiors.
Okay.
Okay.
All right, thank you.
But she's the one that has the responsibility,
Yes.
reasonable cause to believe, where she sees this child on a daily basis.
Even as my cousin is a teacher, it was a high school situation, just one situation that happened, she didn't report it, someone else got around,
Mhm.
and she was arrested.
Your cousin?
Yeah, she was arrested and she went through probation and she was facing losing her job.
For failure to
to report.
And by the way, there's a very old case, Mattingly v. Casey is the name of the case, and it was an appeals court case. It actually predated the Mass Tort Claims Act, where Commonwealth of Mass can be sued in certain instances, but there's a limit and so forth. So today, for example, social workers, the department could get sued. Well, back then, there was a young girl who, she was living with either stepfather and bio mother or the reverse, I forget, and one of them would continually beat her up. And she would be going to school and teachers would be seeing her, and some of it gets reported, some doesn't. I don't know if there's never any court action going on. Well, ultimately, the parent that was beating her beat her so bad that she was in a coma. And somebody sued the department, schools. Okay, yeah, it was the sort of like the non-offending parent, and the appeals court came down with an opinion that, and it's sort of a famous quote that said something like, not every bruise, I mentioned before the bruise, not every bruise has to be reported. It was a really weird, and the main reason why the court, denied any kind of redress to this non-offending parent was that this was the parent that maybe didn't commit the injuries, but stood by, or at least was in the picture while this happened. So while sometimes it's not clear the reasonable cause to believe, there are definitions that I just read to you. But for example, little Nicole, who, in the scenario that I just gave you, maybe you don't have enough. Maybe you're not going to report it. Because maybe the bruises can be explained. Or maybe you are going to report it because of the nature of the bruises, or where they are, or her age, or her mental condition. So, a lot depends on the relationship you have with the child and what you're seeing and so forth. But again, 51A is just the reporting statute. Once you report, whoever reports, whether it's a mandated reporter or any person, then the responsibilities of the department kick in, and that's the beginning. That's 51B. And there are two kinds of investigations. One is the emergency investigation, one is the non-emergency investigation. So under 51B Section A, it just says in general that the department has the duty to investigate, to determine whether this initial report should be substantiated. Because the report that first comes in, again, 51A is just a report. It doesn't mean that ultimately there's going to be a ruling that a child's been abused or neglected. It's just the report. So it's at the conclusion of the 51B investigations by the department, again, whether it's emergency or not, that the department is either going to substantiate that first report or not. And 51B talks about certain things that the social work, that initial investigation should be comprised of. Going to the home, identifying the nature and cause of the injuries, the identity of everybody in the house, the name and age and condition of other children in the house, if any, if that matters at all, evaluation of the parents, the home environment, any other kinds of facts that might hinge on whether the child was abused or neglected by a caretaker. So again, the first part of 51B just says in general what the department would be doing. And that's 51B Section B that says all of that. Now, section C then talks about emergency removal. And there's a standard for emergency removal. What do you suppose that standard is?
Immediate,
Immediate.
injury, threat,
Fair, Roberts?
is what you read.
Nobody has it yet, that's why I'm sitting here silent.
It's
It's reasonable cause again. You're gonna see those words a lot this semester, reasonable cause. So if the department has reasonable cause to believe that a child's health or safety, and you mentioned danger, I think, Norman, is in immediate danger, they're gonna take the child or children in immediate temporary custody. And just going, I put a little graph on the board, 51A, if it gets screened in as an emergency, what would happen is, say in the second scenario that I mentioned with little Nicole, the neighbor that called while you were beating her, whoever the screener is on the other line might identify that this is an emergency. And that means that within 2 hours, a social worker is gonna go out to the home. And within 24 hours, you're gonna get a 51B interim report, and within 5 days, a final report of that investigation. So social worker goes to the home, sees little Nicole all bloody, Danielle ranting and raving, no food in the house, beer everywhere, empty pizza boxes.
How bad can it be? She's getting pizza's expensive.
I don't let her drink it.
So the
And
worker
she gets
said, Thomason, I'm taking your child right now.
Wait, I got 3.
Okay. You want the rest?
I'll take all of them.
You get one, you get them all.
1 and 2 free.
It's a package deal.
I would tell that to my kids when they were growing up. You ever want to call for this, remind them that you have siblings.
If that is the case, remember back to some of the early cases of the state intervening, Prince v. Mass being one of the most important ones. You're talking now about the police power of the state. I mean, not Nicole, Danielle has custody, has liberty rights, right, relative to Nicole. She has custody. For somebody from the state to remove Nicole without a court order, right? You're talking about parents patria, the state being able to intervene because the health, safety of the child is in danger and so forth. So she's gonna remove that child, but what she then has to do is then go to court the next business day. So 51B, if it's an emergency, truly an emergency under these standards, the child is gonna be removed, but then the next business day, then the social worker is gonna be going to court, filing under 119 section 24, and I'll come back to section 24, but I just wanna mention that that's what would happen. She'd have to go to court the next business day in order to get temporary custody from the juvenile court. So that emergency, doesn't last that long until the next, it lasts until, again,
And that is-
the next business. So it was Friday night, it's gonna be Monday morning that you've lost custody of your child temporarily by emergency.
Is that hearing, that?
I'm gonna come back to that hearing. I wanna finish the 51B first. So, that's the emergency removal. Now, coming back to the investigation, in the first scenario, what Kelly said, she's coming to school dirty and this and that, and she didn't have lunch one day, and then I saw her bruise. She calls it in. There's concern, there's reasonable cause to believe that, Nicole might have been abused and neglected, but it's not an emergency. So in that case, there's gonna be an initial investigation over 2 days. And actually, the Department Act has a total of 15 days to come up with a final report. So they're going to go to your home, they're gonna talk to, the school guidance counselors, the other teachers, medical, et cetera, and then come up with a determination whether to substantiate that initial report by Kelly and her, and the school. So that's the non-emergency. The other things that may be happening is that, and this is under 51B, subsections. G is obviously the department has to offer services. H, Danielle will be in the central registry as the perpetrator in this particular family, if in fact the initial 51A report is substantiated.
What is that?
That's bad.
That sounds bad.
That's-
I mean, do you
Yeah,
ever,
the
has
central
access-
registry.
but do they get taken out of it when it's unsubstantiated or unfounded?
Well,
or-
what the statute says is if a report is declared allegation invalid, the name of the child or other identifying character shall not be placed in the central registry. What happens is, and I think it's another section that deals more with the central registry, somewhere in the 29s or 30s in this statute. You're gonna stay in there, and I think you're gonna stay in there for at least a year, it could be more. Once
People that
that,
just
yeah.
report anybody randomly?
And later on, we're gonna read, when we get to medical neglect, we're gonna be reading the Cobble case. And in that particular case, I don't wanna talk about it now because you're gonna be reading it later, but in that particular case, the reason why the father in that case ends up going to Superior Court to, ends up appealing through the administrative process. Even though the department, didn't take custody of his child, all the department did was substantiate one report and then close the case. Substantiated, so there was abuse and neglect, but ultimately closed the case because there was really nothing wrong. But his concern was, I'm in a central registry as a result of that. So he wanted to fight that, and you can. So when I mentioned before, the department being an agency promulgates its own rules and regulations, but it also acts as a quasi-judicial body. So any decision along these lines, the parents, the family, the parties, have a right to appeal through the administrative process. And what do I mean by that, through the administrative process? I've drawn sort of two boxes on the board, one being DCF, agency, the other being juvenile court on the other side. So through the agency, you would have the right, say, a parent came to you and said, Danielle came to me and said, the department just investigated me, and, they're saying that I abused and neglected my daughter. Is there anything I can do? Yeah, you can. You can go to a fair hearing, what's called a fair hearing. Are the hearings really fair? Well, they're all department employees, but they're fair hearings. And at that fair hearing, the administrative officer would review the evidence and decide whether that the worker or whoever made that decision before was, again, a reasonable decision. And there's a standard for that, but I forget what it is right now. But it's a low kind of standard. So remember that as you go through department determinations. Later on, we talk about service plans and review of children in foster care and all kinds of things like that. But while you might have a juvenile court proceeding going on at the same time, you still have an agency involved with its own repercussions, its own rules, its own regulations, its own determinations that parties have a right, if they're aggrieved, to go through the process. And it's chapter 30, which is the Administrative Procedure Act. So you start at the department level and you can go all the way up. In other words, whatever levels of the department that you have in terms of hearings that you're aggrieved by, whatever the decision is. After that, then you can appeal to a court, Superior Court. After that, you can appeal to an appellate court as well. So that's just a little bit about the administrative side of things. Back to 51B, because I didn't finish. Another thing that 51B mentions, and we'll deal with that next Thursday when we go into the child sexual abuse assignment. If the department substantiates after a 51B investigations, a pretty serious form of abuse or neglect, the worst being death, serious bodily injury, sexual abuse, they are also going to report it to who? The DA's office. So they, from day one, you have the Department of Children and Families, which, by the way, I put on the board Section 1, which is the preamble, the purpose of the policy and the purpose behind these proceedings, strengthen and encourage family life. The department was created not to be antagonistic, not to advocate, directly against parents, not to make sure that parents lost rights forever, but to strengthen and encourage family life, to offer services, to help families or help parents who are unable, for one reason or another, to take care of their children. So you have that on the one hand, but then you have an agency like this reporting to the Criminal Enforcement Punishment Agency, the District Attorney's Office, in certain cases. So the District Attorney's Office gets this information. It's the 51As, the 51Bs, the service plan, and so forth. So keep that in mind. In some of the serious cases, especially child sexual assault cases, the district attorney gets the information directly from the Department of Children and Families.
Is that what, Joe, is that after they've investigated and at what level? I mean, reasonable.
Yep. So 51A comes in, suppose the allegation was that you had sexually abused Nicole, right? The department's gonna get it, and then the department's gonna transmit it to the DA's office as well, and you'll probably be not only, lose custody, but you'll be criminally prosecuted as well.
Can you be criminally prosecuted on something that has been proven?
Yes.
Well, you know what I mean,
Yes.
I know the whole.
Yeah,
standard.
save the talk for next week, because I have a huge case, well, it was a huge case at the time, that you guys will be working on, that started as a care and protection case and also became a criminal case as well, in which the father was criminally prosecuted, while the CMP was ongoing. So that's 51A and 51B. Again, 51A reporting, 51B investigation and duties of the department once the report goes in. I want to come back to Section 1 because there's a lot to it. Sometimes with statutes, you have like a little piece of the statute somewhere that tells you this is the purpose. Well, Section 1 is 6 paragraphs. It's really long. And also 110 CMR, the Code of Mass Regulations, also has a little policy purpose clause as well. The first paragraph of 110 Section 1. 110, I'm sorry, 119.
Okay.
Was I saying 110 for a while?
Well, you just did that.
Okay.
Danielle went on red alert.
I just did it once? Okay. 119 Section 1, I'm sorry. First paragraph says the policy is what I just said, to strengthen and encourage family life. That's the policy of this Commonwealth. The second paragraph, the purpose of this chapter is to make sure children are protected. Hence the name of the statute, Care and Protection Statute. Third paragraph is just one sentence, and it's the standard. The health and safety of the child shall be of paramount concern and shall include the long-term well-being of the child. By the way, this statute has gone through so many revisions since the old days with Department of Welfare and so forth. That sentence is one of the newer amendments. The focus used to be only on parental unfitness. Now the focus is on the health and safety of the child. The next 2 paragraphs are not talking about juvenile court proceedings. They're talking about department proceedings. And they mention, and it mentions what best interest means in all matters and decisions by the Department of Children and Families. It's interesting, because it's not telling you, well, what is best interest in the context of the care and protection proceeding. It's telling you what the department would be determining best interest is in the context of the department, offering services and so forth. It also mentions that the department, if they have a child 12 or over, the department is gonna be, listening to that child is gonna be mature for purposes of offering statements and so forth. So that's kind of a magic age with the department. Later on, you'll see in other contexts, the age 14 being a magic age as well. So I wanted to say that about Section 1. So Section 1 is the purpose clause. I mentioned I was going to come back to Section 21, the definition sections. Section 21 defines custody, and here I want to mention a couple of the cases you had to read. What's the definition of custody? What's important once the department gets custody? The department being an agency. Norman?
Part of it is control over that person, and part of it is
Control of the child in terms of what? Give me an example. So in the example where the little Nicole was taken Friday night, right? What decision can the department then make about Nicole? Place of abode, where to put her, right? Place of abode. What else? So suppose that then the department goes in Monday morning, and we'll talk about what the standard is, but Monday morning gets temporary custody. What else, what other decision is the department going to be making?
Child's medical.
Medical? What else?
Schooling.
What?
Schooling.
Schooling?
I mean, they're not always placed in the town that they,
Okay.
I don't know what they do about that.
Yep. What else? Marina?
Legal supervision and protection.
Yep. What else?
contractual, decisions about.
What about Danielle? Mom? What-
Visitation, right?
Visitation?
I need to see her.
So let me go back. The Isaac and Jeremy cases were very, very important cases. They came about as a result of the department getting permanent custody in one case, temporary custody in another case, and the judge making a kind of a big mistake. Isaac was the permanent custody case. What did the judge do that was basically wrong? Danielle?
Well, he was ordering the agency, basically telling them what to do, which really wasn't his job.
Why not?
It's their job.
Why is it their job?
It's administrative function.
Well, I have here in my notes, executive versus judicial.
Yeah, yeah.
That they can review DSS for action and error, but they can't control the department.
Why?
But they can't.
What does the department have? We just said it.
Control.
Custody.
Custody.
Custody. But that's not unlimited, right? If it becomes arbitrary or capricious, right? That's the standard. The judge can review for abuse of discretion. And those cases became big because what resulted from those two cases was defense attorneys, attorneys representing parents and children going and filing what's called abuse of discretion motions. When, say, Danielle comes to me and says, they took my kid 2 weeks ago, I haven't seen her, all right? I haven't seen her. Abuse of discretion. And that goes to the other case, where we have the custody of a minor case. Because what would the department be doing wrong in not affording Danielle visitation? What's the standard for terminating visitation? Department has custody, that doesn't mean the department can on its own say, sorry, what does the department have to do? Suppose she's really bad. And suppose she just killed the other two children.
Max.
That boy.
And the department does not want her to have visitation with Nicole. What does the department have to do?
Another hearing?
Yeah, has to go to court, the judge has to find that what?
Unfit.
That she's
Not
an-
unfitness, because that would be ultimate at trial. Marina?
That she's an unfitted parent for this particular child, right?
It's not, again, it's not unfitness, it's just the determination of visitation, which is usually pre-trial.
How supervised?
Is that the current?
For a judge to be convinced to terminate visitation, what does the department have to show? Nope.
No, that's
You-
termination.
Again, you guys are going too far,
The
too
fair
far
preponderance.
into
Fair,
trial.
it's a fair preponderance.
That the visits will
Very
harm the
convincing.
child.
Harm.
No.
The visits will harm the child. The visits will harm the child. So you can't, the department can't sua sponte on its own, say, you know what, sorry. So that's one example of a abuse of discretion motion where the department might have acted arbitrarily, capricious. And where does it come from? It comes from, the department, again, being an agency, should be following the law. The statute, case law, its own rules and regulations. Suppose that when the department took Nicole, Danielle said, Nicole's aunt lives one town over, please put her there, that means she can go to school Monday morning, etc. Instead, the department puts her in a foster home 50 miles away. Again, that could be the subject of an abuse of discretion motion as well. Because the department, once the department takes custody, it doesn't mean unparalleled, in terms of control of the child. It is an absolute, total control. The department still has to follow its rules and regulations. And part of its rules is, let's look for family placement first. Again, going back to the policy and the purpose, strengthen family life. So if there's a family member, ready, willing, able, passes in terms of criminal checkpoint checks and so forth, the department should be placing.
Sometimes
and
they
that
don't
could
get
be
the option. I got a knock on my door once at 2 a.m. with my nephews.
Uh-huh.
I don't know where the ready and available is.
I mean,
I have a big family with lots of stories.
It's all wills and trusts we learned. It's-
Wasn't my
it's-
sister's kid.
It's interesting though that, I guess it turns out that way, but I mean, you could say what came first, the chicken or the egg? I mean, if the state can place a child with a relative, they would rather do that for financial reasons.
Absolutely, that's.
Well, yeah, but I mean, they're not gonna get paid like, $160 a day extra for an extra staff worker, that kind of
Right.
thing.
Well, foster parents and family members get the same.
But, I mean, it's still cheaper than probably putting it into a private residential facility, right?
Yeah.
One of the cases, I think one of those cases.
Sure.
Well,
But what is most important is the policy and purpose of DCF to begin with, and it's all about family.
Yeah.
So if there is family, and family is available, and family qualifies, then that's where the child or the children should go. There's another section of the statute that I want you to turn to now, if you have it, and that goes to evidence. And we'll be coming back to evidence occasionally, because 21A first starts off saying that basically evidence is the same as in any other court, because it says evidence admissible according to the rules of the common law and of the general laws. But then the statute goes on and says, may include reports to the court by any person who has made an investigation. Okay? That is the court-appointed investigator. Once a case goes into juvenile court, once a care and protection case gets filed, the first things that happen is appointment of counsel, and that's under section 29, appointment of counsel to parents. If parents have differing interests, it would be more than one counsel, counsel for mother, counsel for father, counsel for stepfather, etc. appointment of counsel for children. Again, if children have differing interest, you might have different attorneys for different children as well. And at the same time, there's the appointment of what's called this court-appointed investigator. That person has the responsibility between the time of the appointment and the next court hearing to go out and, quote, investigate the facts. And so this is different from DC. This is not a DCF investigation. This is not a DCF worker. And some court-appointed investigators are attorneys, more and more lately with the economy too. A lot of attorneys want to get those jobs too. They don't have to be. So they get the appointment, then they go out and they do the same sort of thing, you know, see the child, see the family, look at medical records, look at school records, etc., and write a report to the court with the facts and recommendations as to custody and whatnot. So there's that kind of report. And then there's another kind of report that Section 21A talks about, and that's from the department. That's the social worker kind of report. So suppose that in Danielle's case, the case gets continued, you know, and about a month later, you've got the report of the investigator, and also, say Elizabeth is the social worker, she'll also have a report that also gets filed with the court and given to all the parties, and she'll be saying, you know, what's transpired since removal and so forth. So two kinds of reports. The investigator's report, there's a lot of case law, about. Typically, it contains hearsay, sometimes even tone-of-voice hearsay, and they generally get allowed. Sometimes not verbatim, sometimes attorneys file motions to strike pieces of them and they're successful. But the key is that this investigator is like an arm of the court, identifying for the court, you know, the basic, what's going on in the case. The investigator also becomes a witness and subject to cross-examination. Therefore, that's part of the reason for allowance of the report, even with its hearsay contained in it. The social worker's report, again, the same sort of thing. The social worker is also subject to cross-examination. I think we have a case that talks, yes, the care and protection of Bruce deals with a number of issues, but one of the issues it talks about was the admission of these various letters to the court prepared by DSS personnel. And the court mentions that, you know, they could be limited, they could be redacted, but for the most part, the judges do let them in. Again, you can attack them, you can say there's opinion in them that shouldn't be, or you can say there's, you know, there's a source in here, I don't know who this source is, where is this source? You know, that should be taken out, that should be redacted, but for the most part, they do generally come in. So getting back to evidence is evidence, on the one hand, like any other trial court, on the other hand, in other trial courts, you don't generally allow hearsay reports like this because they're cases about children. Okay, I said I was going to come back to how the cases begin. So 11924 is very, very, very important. That's the procedure, how a care and protection case starts. But let me just say, going back to 51A and 51B, just because you have 51As that are substantiated, it doesn't mean that there has to be a care and protection case. So Danielle could have, you know, in her family, she could have multiple 51As that get substantiated, one after the other, and, you know, the department offers services and service plans, and she's working with the department, but the department never goes into court to get custody of the children or the child. Okay. So it's not a mandate. So depending on the first paragraph of 24 is the allegations. So if, and by the way, it's, I keep saying the department, but the petition, the statute itself says a person may petition. So technically, anyone could file, anyone over 18 could file a care and protection petition, but 99% of the time, it's the department. And these are the allegations, and there's like four subparts to it. That the child is without necessary and proper physical or educational care, or growing up under circumstances damaging to sound character, or lacking proper attention of the parent, or has a parent that's unwilling, incompetent, unable. So in general, the allegation is that what's going on in this family right now is this parent is unable, for whatever reason, to care for this child. So say Danielle's problem was substance abuse, and the department had been working with her for a long time, but it just, it was getting worse. So at some point after a number of service plans, the supervisor in the department said, we should go into court and file under Section 24. Okay, so this would be a non-emergency, but it's still a care and protection case being filed, right? Yeah.
So, in the emergency case where you have the removal,
Yep.
is that always an ex parte?
Okay.
Or
in the emergency case, they came and took Nicole Friday night. So Monday morning, Marina, the social worker, she's going to be in first session in Lowell, filing her petition, her affidavit. The department's attorney might be there just because they're there on other matters, but it's Marina that knows about the case. You're probably not going to be there.
Are the parents notified about that? Or
You're not, well, you are in a sense, but you're notified because if you were there when your child was taken, right? But you don't necessarily know that you've got a right to be there Monday morning.
Do that.
You don't. You don't. You're going to get notice under Section 24. What happens is you get a summons, and the summons indicates not only that this is a care and protection case, but the summons also gives you the worst case scenario. It says right in the summons that this case may become, and I'll talk about worst case too, may become an instance where the court can dispense with your consent to adoption, all right? But it was Friday, Monday morning, more than likely, at some point you're getting this. Are you gonna show up Monday morning? Probably not. In 99% of the cases, it's the social worker and the judge.
If the parents showed up, would they be heard?
Maybe informed. Again, it's not a real hearing in the sense that somebody's under oath and the court is taking testimony.
Can't imagine.
Yeah. So the standard is, because you guys said it before for your emergency hearing, reasonable cause. And the standard is in the statute. If the court is satisfied after the petitioner, and it says the petitioner testifies under oath, but it doesn't really have it, that there's reasonable cause to believe the child is suffering from serious abuse or neglect, or immediate removal is necessary to protect, the court may issue an emergency order transferring custody of the child up to 72 hours. Now, I'll talk about 72 hours in a second, but that's it. That's an emergency hearing. Think of it like an injunction, right? Ex parte hearing. You mentioned ex parte hearing. It's still an emergency in the sense that the child or the children were removed either the night before or the weekend before, and it's still sort of under the police power of the state intervening. Parents patriae, protect this kid. I need an order for emergency custody. At the same time, as I mentioned, if parents can't afford counsel, they get put on counsel. The case gets continued for 72 hours, and hence what's called the 72-hour hearing, which doesn't always happen 72 hours later. Anybody know why?
Maybe it's also a weekend or
Holiday.
people
The
can't get their.
motion's usually filed.
Because what?
The council can file a motion to delay the hearing for.
And why would that be? the parties have a right, the parties being, you know, the parents and the children as well, right, to be heard 72 hours later, because again, what the court, what the department has is just this emergency, transfer of custody for up to 72 hours. Now, think in terms of how much 72 hours are, and if you've got counsel, you also might wanna have time,
Or discovery.
you know, time to prepare. There are instances, and that was the Emmanuel case, where the, sometimes parties actually waive the 72-hour hearing. For one reason or another, you know, suppose you met with your client, and client's the mother, and, you know, she's not doing so well, and, you know, you might decide between the two of you that, you know, that, you know, this is an ongoing case, it's gonna last for a long time, then maybe she wants to get her act together, and maybe she doesn't wanna have the court actually hearing the bad facts right now, and waiting till much
She
later
has good
on,
facts.
when she's not unfit anymore or whatever. So there might be various reasons for either waiving the 72-hour hearing altogether, or, you know, agreeing to a continuance of the 72-hour hearing. And some 72-hour hearings can be just like that, real quick. Some can also last for days, because they are in effect and could be trials, right? The standard for the 72-hour hearing is not in the statute. Where's the standard for the 72-hour hearing? It's in one of the cases that you had to be.
Fair.
It's fair preponderance, and in what was the case?
Santosky.
No, not Santosky, that's another one. Because now you're doing a 72-hour hearing, not the final trial. It's still for the court to decide temporary custody pending the hearing on the merits. So you're gonna go up from reasonable cause to a middle. And it's fair preponderance, Alina's right, but what's the case? The Robert case set the standard. Before Robert was decided, courts would pretty much just go along with, okay, we're back in again. If they look at it, we used to look at it more like a status hearing. Okay, what's going on? Our department is custody, children are in foster care, mother's supposed to get counseling, blah, 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 and they would just continue it. Until Michael Kelly decided that he was gonna take the case up to the SJC. He actually argued for a higher standard. He argued for clear and convincing, but the court came down with fair preponderance. And that's the case, whenever there's arguments about standard of proof, what kind of balancing test goes on? There's a famous US case, nothing to do with parental rights, but it was actually a big Social Security disability, where the court balances the private interests,
Which is a governmental
which
interest.
the government interests versus the,
Public policy.
no, wait a minute, I just lost. Oops. Have it here. The private interest, oh, I'm sorry, yeah, the governmental interest and the risk of error, right? Does this sound familiar for those that had common law? Matthews v. Eldridge. It was a disability case, but it's a famous, you know, so, Robert cited used the Matthews v. Eldridge test, and the court basically said in Robert's, look, you know, parents have this and again, it goes back to the early cases we already read. Parents have this liberty interest. They've lost custody of their child, and it's gonna be a long time till the case goes to trial. Therefore, the department should have a higher burden than just reasonable cause. So the court has to be convinced, at least by a preponderance, to continue temporary custody with the department at the 72-hour hearing. If there's no 72-hour hearing because there's no, There was no emergency removal. There could still be a temporary custody hearing, and it's under section 25, and the burden is the same. It still would be preponderance. So if in, Nicole's case, the department filed a care protection petition, but did not, did not seek emergency removal right away, but was seeking custody, she still would be entitled to a temporary custody hearing where the burden would be preponderance. So regardless of emergency or not, if the department wants temporary custody, they still have to prove it by a preponderance of the evidence. They have to prove that the child or children might be in danger of abuse or neglect. Now, section 26, and now Norman, you cited Santosky. Section 26 is your trial, your final hearing, another very important section of the statute. And what's the burden in what case? Norman, you just said it.
Wasn't that clear and
Convincing. And what was the case you cited?
Santosky
Yeah.
v. Kramer.
And Santosky v. Kramer was actually a U.S. Supreme Court case
Yeah.
that set the standard clear and convincing. That meant that every state could, the states could not go below that standard. They could go above. I mean, the state of Massachusetts might have said, you know what, let's try for proof beyond a reasonable doubt, and they wouldn't be violating. But they stayed with clear and convincing evidence, which is still a civil sort of standard, but it's much higher than preponderance. So if this case goes to trial, the department has to prove that parent or parents are currently unfit towards each and every child. You'll see later on that it's in fact possible for a parent to be fit towards one child and unfit towards another child. By the way, section 26 also mentions about the child being identified. The care protection cases and the adoption cases are the cases in which you really don't see the children in the courtroom. They could come once to get identified. They must get identified, whether it's because the judge going to the hospital when the child is seriously hurt, or the social worker bringing in the child at least once to be identified. Then after that, the child might be coming to court, but, sitting in the hallway or whatnot, the child is not typically in the courtroom. So 26 section 1 mentions that the child gets excused from hearing and the court proceeds to hear, the evidence. And if the court finds the allegations proven by clear and convincing evidence, then the adjudication is that the child is in need of care and protection. So that's what the court, that's what the court's decision is. I find that Nicole Thomason is in need of care and protection. That's the adjudication part of the trial. It's the dispositional part of the trial that there are alternatives. And they go from, least case scenario in terms of government intrusion in Danielle's family to worst case scenario. So Nicole might be adjudged to be in need of care and protection, but the court might actually allow her to remain in the home with Danielle, with supervision by DCF and offering services. So that's one alternative. Another is just transferring, custody to another person, grandparent, aunt, etc., another agency, or typically the department. Worst case scenario is mentioned in 26 subsection 4, and that's the, in effect, termination of Danielle's parental rights. 119.26 section 4 cross-references the adoption statute. That's why I gave you that as well. Chapter 210, section 3. Let me just say a little bit about
Section 26.
yeah, 119.26, subsection 4 allows the juvenile court to dispense with your consent to adoption, in other words, freeing your child for adoption and terminating parental rights. This statute was amended in 94. Before 94, if the department said, you know what, Danielle's never gonna get her act together. We've worked with her for years. Her children are getting older, we need to free them for adoption. Well, what would happen is the care and protection cases used to just deal with parental fitness. And worst case scenario was parents lost custody, but they were always entitled to come back for review and redetermination. So say 6 months later, she was clean, she could come back and ask for custody.
After the child was adopted?
No, I'm saying in the true care and protection case, what used to be care and protection only in the juvenile court. And in the cases where the department said, you know what, that we need more than that. This child needs to get adopted. The department would have to go to probate court. That's why you have the Chapter 210, Section 3. The department would have to go to probate court, file a petition there, even when the C&P was still open in juvenile court. So you'd have the care and protection in juvenile court. When I say still open, even though she loses custody, because she hasn't lost parental rights, the case still remains open. The court holds annual reviews every year. As I said, she can come in on motion. So the cases would stay open, and just the kids will languish in foster care, and there were all these measures to try to free up kids and in the interest of children and whatnot, the Adoption and Safe Families Act, et cetera, et cetera. So the legislation involved then, let's have the juvenile court have the same authority as the probate court to terminate parental rights. So even if a case starts off as a care and protection only, we're just looking for custody temporarily, we're gonna help this family, we're gonna offer services, somewhere along the line, the department might on motion or make the determination that our goal now is not reunification, our goal is termination. And it gives the juvenile court judge the authority to hear that as well. And 210.3, I'm not going to talk about them right now, but 210.3 has a list of the dreaded factors, these 14 factors that the court looks at in determining whether it's the best interest of the child to be, or is the parental rights to be terminated. Some of the factors deal with, a child being in foster care for a certain number of months. Some of the factors deal with children that are younger, that should be free for adoption earlier. So some of the factors deal with the parents being offered services, but not taking advantage of the services. Another factor deals with the parent, not following through, for example, not visiting, even if the parent doesn't have a car and the location is 50 miles away, but that's the parent's fault. Anyway. So that's the worst case scenario in these cases. So some of these cases say care and protection of, or custody of, and other cases say adoption of, or petition to dispense with, etc. And that's pretty much the overview that I want you guys to have for now. I just want to see if there's anything I didn't mention. There's another piece of the statute, and it's 29C, which has been amended, so I'm going to give you some of the newer amendments later on. There were some amendments in January that deal with not only aging out, but a couple of other things, but just the general thing to remember that every time a court rules on whether the child should be removed from the home, another factor that the court considers is whether the department has in fact made reasonable efforts. and that's a big requirement, the reasonable efforts requirement, made reasonable efforts to work with the family before removal. So the court actually signs what's called the 29C certification, making sure that that in fact has been done. So in terms of the 72-hour hearing or the temporary custody hearing, the judge looks at two things. One is, has the department proved by preponderance of the evidence that the child's in danger of neglect or abuse, and has the department also shown reasonable efforts before removal? So it's sort of like a two-piece test that the court looks at before awarding custody to the department in these cases. I wanted to mention Zelda, but I will do that later on because there was a case that my law partner worked on that I want to mention, and it's going to take, the discussion will end up taking a little bit too long. I actually have a handout for you that I can send you electronically too, but I had made a bunch of copies. When we discuss domestic violence next week, the reading's very, very short. I think you've got like one case and a guardian ad litem report, and I think that's about it. So in here is I'm handing out, it's the power and control wheel, characteristics of domestic violence perpetrators, children, etc. So here it is, take the handout with you. If I remember, I'll send it to you electronically so you can have it on your CD too. So take a copy before you leave. So we'll start domestic violence. Again, while we're doing the specific kinds of topics like domestic violence, child sexual abuse, we're still reviewing these statutory procedures. So today was merely sort of like an introduction to the care and protection process.